Chapter 3, Section 1, The Courts, Judicial Review. The federal court system is the judicial branch of the federal government. Article 3 of the Constitution establishes the Supreme Court of the United States and authorizes Congress to create inferior courts at its discretion. Today, the federal court system consists of 94 trial courts, known as district courts, and 13 appellate courts, known as courts of appeal, in addition to the Supreme Court. The primary purpose of the federal court system is to adjudicate disputes that arise under federal law. In some cases, these disputes concern the constitutionality of actions taken by the government. For example, a defendant charged with a federal crime might argue that Congress exceeded its constitutional authority when it passed the law that criminalized the defendant's actions. The federal court system's ability to decide these types of cases, known as judicial review, is an important feature of the system of checks and balances, but it is not expressly authorized by the Constitution. Instead, the constitutionality of judicial review was defended by Federalist 78 and formally established by the Supreme Court in the landmark case Marbury v. Madison, 1803. Federalist 78. Federalist 78, authored by Alexander Hamilton, is one of the several Federalist papers that discusses the role of the judicial branch. In number 78, Hamilton addresses the concern expressed by some that permitting the courts to declare laws invalid would elevate the judicial branch above the other branches of government. In response, Hamilton confirms that the courts will have the power to void unconstitutional laws and defends the practice, asserting that Congress cannot be expected to police its own authority. Instead, Hamilton argues that judges should have the limited power to invalidate laws that conflict with the Constitution, while also reassuring his contemporaries that the judicial branch is the weakest branch of government, and that the power to invalidate laws does not carry the same potential for harm as the legislative and executive powers of taxation and criminal prosecution. Although some have questioned whether the framers of the Constitution intended to authorize the courts to engage in judicial review, Hamilton's defense of the practice in Federalist 78 indicates that judicial review was generally understood to have been an implicit power of the judicial branch from the time that the Constitution was first adopted. Marbury v. Madison. The central dispute in Marbury v. Madison, 1803, arose from the contentious presidential election of 1800. President John Adams, who had been voted out of office, attempted to nominate as many of his supporters as possible to lifetime appointments within the federal government before his term expired. William Marbury was one of these last-minute appointees, and his nomination was quickly confirmed by the Senate. The outgoing Secretary of State, however, was unable to deliver Marbury's commission to him before Adams's term ended, and the new Secretary of State, James Madison, refused to release it. Marbury then filed a lawsuit against Madison in the Supreme Court, alleging that the Judiciary Act of 1789 had granted the Supreme Court original jurisdiction to issue an order, known as a writ of mandamus, to compel Madison to deliver the commission and allow Marbury to take office. In the court's written opinion, Chief Justice John Marshall agreed that Marbury had the right to his commission, and that language of the Judiciary Act of 1789 had clearly granted the Supreme Court the authority to issue writs of mandamus. However, Marshall determined that the court could not issue the writ because the Judiciary Act of 1789 had unconstitutionally expanded the original jurisdiction of the Supreme Court beyond the scope of Article 3. Marshall declared it was iron logic that the Constitution would prevail when a conflict arose between the Constitution and other federal law. Moreover, Marshall asserted the authority of the Supreme Court to adjudicate such a conflict by declaring that it was emphatically the province and duty of the judicial department to say what the law is. Thus, the doctrine of judicial review was formally established. Ultimately, the decision in Marbury v. Madison was significant in two respects. First, by asserting the constitutional imperative of judicial review, Marshall confirmed an important check on the legislative and executive branches. If either branch exceeds the scope of its constitutional authority, the court system can effectively void the law, regulation, or executive order that violates the Constitution. Second, Marshall strengthened the role of the federal courts in a masterful way. Formalizing the power of judicial review expanded the scope of the court system's constitutional authority. But the fact that Marshall was able to do so while striking down a law that had enlarged the Supreme Court's jurisdiction lent legitimacy to the potentially controversial decision.